When you think of a homeowners association, you probably think about rules for lawn care or maybe the color you can paint your front door. But what happens when the people actually making those rules just disappear? When the entire leadership of a community just collapses overnight? Well, today, we're going to dive into the true story of an HOA that found itself right on the edge of chaos.
And it all really boils down to this one huge question. Seriously, think about it. Can one single person legally be in charge of your entire neighborhood? The money, the contracts, all the big decisions. Just one person calling all the shots? Is that even legal? Well, we're about to find out, because one community lived through this exact scenario, and you guessed it, the whole thing ended up in court.
So let's set the scene. We're at the crossings at Willow Creek, a pretty standard homeowners association in Arizona. And just like any other HOA, it's supposed to be run by a board of elected volunteers, your neighbors. But in the summer of 2015, something went sideways, and a massive leadership crisis just erupted out of nowhere. So what happened? Well, in July of 2015, 3 out of the 4 board members just up and resigned. Poof, gone. In an instant, 75% of the HOA's leadership vanished, leaving the entire community in a state of, total confusion. And this wasn't just an inconvenience. It was a critical, time-sensitive problem. Because not only was there just one person left on the board, but the HOA's contract with its management company was about to expire. So the one remaining member felt like they were in a true emergency situation, what the law calls exigent circumstances, with nobody else around to help. So, with the weight of the entire community on their shoulders, this last board member standing decided they had to do something. They took charge and started making decisions all by themselves, just to keep the lights on and keep the HOA from falling apart. And this one-person show went on for months.
Okay, so check out this timeline. For a full 6 months, from July 2015 all the way into the new year, this one person was running the whole shebang. They were handling all the HOA's business completely alone. Then, in January 2016, they made a really big move. They single-handedly appointed new members to fill those empty board seats. And that was the move that got other homeowners to say, whoa, wait a minute.
And this is where our legal battle begins. See, a couple living in the community, John and Debborah Sellers, they saw what was happening, and they believed a major line had been crossed. So they decided to officially challenge whether it was even legal for one person to appoint an entire board without a community vote or, an actual meeting.
So on April 11, 2016, the Sellers made it official. They filed a petition. They weren't just complaining to their neighbors, they were taking the HOA to court. Their argument was pretty simple. The decisions made by that lone board member, especially appointing a new board, were totally illegal.
Now, their whole case really hinged on this one specific law, Arizona's open meeting law. This law is all about transparency. It basically says that anytime an HOA board does official business, and appointing new members is definitely official business, it has to happen in a meeting that's open to every single homeowner.
Now, here's where it gets really interesting. When they were hit with the lawsuit, the HOA didn't even try to fight the main charge. They basically said, yep, you got us. We technically did violate the open meeting law. But, and this is a big but, they argued they shouldn't be penalized for it because, hey, it was an emergency.
And because the basic facts weren't really in dispute, everybody agreed the law was broken, the judge didn't even need a full, drawn-out trial. They were able to issue something called a summary judgment, which is basically a final verdict when the evidence is so clear-cut you don't need to argue about what happened.
And the judge's decision? A summary judgment for the homeowners, John and Debborah Sellers. It was a clear-cut victory for them. The court officially confirmed that the HOA had acted improperly and broken state law. But the punishment wasn't quite what you might be thinking.
The judge's order basically had 3 parts. First, the HOA had to pay back the sellers for their court filing fee. Okay, makes sense. Second, and this is the key part, the judge decided not to hit the HOA with a big financial penalty. But third, they gave the HOA a very stern warning. If you ever do this again, there will be a penalty.
So why no fine? What's going on here? Well, the answer is hiding in plain sight, right in the text of the law itself. See, the statute says the judge may levy a penalty, not shall or must. That one little word, may, gives the judge discretion. It means they can look at the whole situation and decide if the punishment really fits the crime.
And this, right here, brings us to the biggest lesson from this entire ordeal.
The judge's decision shines a huge spotlight on a critical difference in the eyes of the law, the difference between an honest mistake made under crazy pressure and a malicious, deliberate power grab.
The judge actually explained their reasoning by comparing this case to a previous one, and it makes things crystal clear. In that other case, an HOA got hit with a big fine because they routinely and repeatedly broke the rules just to serve its own convenience. But in our case, the judge saw something different. They saw action taken because of exigent circumstances. It was a one-time thing, not a pattern, and it was all based on a mistake about the law's requirements.
So the takeaway here is actually pretty simple, but it's incredibly powerful. In the courtroom, intent is everything. The judge didn't see someone trying to become a dictator of the neighborhood. They saw a person trying their best to solve a crazy, unprecedented crisis. It was a mistake, not malice. And that distinction made all the difference in the world.
And that really leaves us with a final critical question for anyone who lives in an HOA. If your board breaks a rule, how do you tell the difference between an honest mistake and a deliberate grab for power? Well, this case gives us a pretty good roadmap. You have to look for patterns. Was it a one-time thing under pressure, like at Willow Creek, or is it something that happens over and over again because it's convenient for the board? The answer to that question could be the key to protecting your rights as a homeowner.